Supplementary transaction. Hmm.
My lord,
Mention, my lord, one criminal appeal means custody more 11 about 11 years, but not listed, my lord. Are you giving so many members?
Land acquisition method.
Officers that else are not come.
Yes.
My lord, substitution petition has filed that in the aforesaid case, the petitioner has died, leaving behind his wife, 2 sons, 2 daughters.
Keep the memo. Keep the memo.
my lord, one mention memo already filed 5462, CR number 164/2019. My lord, interim order आपको थिला फाइल कराइला, सडन ची फाइल है। my lord, बालापुर डिस्ट्रिक्ट होउन है। CR 164/2019.
Okay, it is noted down. Item 1 कौन मेमो पढ़ुछन कौन आमे नहीं आसु ना जाई we have noted down the numbers. Yes. But item 105 the list that your lordship are this matter enters a seniority of income tax matter. Your lordship fixed it to supplementary list for last Tuesday. We'll see the next week. First of May I pray blood and let it come on 1st of October. We'll see that. Just mark. Okay.
ନାହିଁ ଆଜି କାହିଁ ଡିମ୍ ଅଛି ମୁଁ ତ ପାଇଲିନି ତାକୁ ଡାକିଥିଲି କଣ ହେଲା somehow it is not working today.
Supplementary list, item number 1.
Copy of the ultimate affidavit was ultimately served on me today in court. Now, before your lordship may kindly see order dated 29/8.
Yes. Yes, Mr.
29/8, your lordship has seen the order. Now, if your lordship sees the affidavit which has been filed, copy which was served on me today, this question which has been posed by your lordship has not been answered therein. They've said a lot of things, but this particular point has not been answered. Hmm. Hmm.
Mr. Mishra, all these documents are already in the record.
Everything is on
These
record.
are all jumbled up with the affidavit. These are all with us. The relevant one is the
Paragraph 10 onwards. Paragraph 10 onwards is basically the, or paragraph 9.
Mr. Mishra, which are the relevant paragraph according to you?
May I take my two relevant documents first?
Yes.
Yeah. Well, straight away come to page 45.
Page 45.
Now, this is the inquiry report.
This is the only document for the report.
The report basing on which that order has been passed. Now, Marot will kindly mark the mutation case number. It pertains to the petitioner's case as referred to in the inquiry in the order. This is the 1924. Now, Marot.
What has been written here?
Marot here. Marot, may kindly see. One, some of government land before these settlement was Chota jungle. In all record, the Kisam is jungle and expanded details of Kisam is of Chota jungle. The certificate plot number 1958 comes under DLC list. That is, this will come to my note that forest. The suit land given on lease to Lessee Sri Kumar Swami by WL case number 1278 1974 for agriculture purpose and saying is sold to Tilottama Vahinipati by registered sale deed number 3336 dated 15/1/1982 by wife of the lessee. However, the same land is lying hollow with
Follow.
recently planted saplings of papaya trees and its land is bounded by compound wall. Also is not used for agricultural purpose.
So maybe in the geotech they found that there is Murum Road in the geotech photograph.
No.
What has been referred to in the order.
What other document you want to place?
And another document, Malama, can you see page 44, just the previous page.
Yeah.
Now, the petitioner has relied upon a DFO office report of the DFO. It is there in the annex in the writ petition, where the DFO said it is not forest land. But again, because after receiving that letter, we had doubt. So we again wanted clarification. Now, Malama, can you see page 44, annex of K by 5. This is the revised verification of land report.
Which one?
Page 44, man.
42.
44, man. 44.
40.
Just the previous.
Oh, revised verification.
Yes.
Yeah.
So, in continuation to this office letter number under reference, this is to inform you that subject plot number 1958, Kata number 805, area 106 Boga is verified and found recorded in the DLC report. Now, my lord, these are the two documents which
DLC report, no?
district level committee, for example. Now, my humble submission to this honorable court will be: these are the two documents which were not produced before this honorable court by the petitioner.
So once it is recorded in the DLC report, then what would be the consequence?
Consequence will be, my lord, it will be jungle Kisam. It cannot be.
It cannot be leased out.
It cannot be.
No, but if in spite of that, if you have leased it in favor of Mr. X or Y, so
that's why the result. That's why the result of proceedings.
A particular, according to you, if a particular land is recorded in the DLC report, that should not be leased out to anyone for any purpose. Is it your case? Then how you leased out to Mr. X or Mr. Y? Then he transferred, of course, that's a different matter. If it is a Chota jungle, question comes that whether it could have been leased out. But you have leased it out for agriculture purpose.
Yes, Westland lease. This is Westland lease, my lord, no.
No, whether such a land
can be leased out for agriculture purpose.
You are saying that cannot be leased out.
No, I'm sorry.
Please make your stand clear.
It can be only leased out for agriculture purpose.
So
that is the purpose of
the land which is recorded in the DLC report or it is mentioned as a Chota jungle, it can be leased out only for agriculture.
Agriculture.
Okay. So suppose somebody has, what do you mean by, let us say, agriculture purpose? Agriculture, does it only, according to you, include a particular type of crops or it includes many things? As per the definition of agricultural purpose, if you see the Google, that what is the definition of agriculture purpose? So he has planted some trees, etc., whatever it may be. What does it mean by agricultural?
Now, agriculture means there has to be some crops.
No, you see the meaning of it. Have you fixed in that way that you are to agriculture this particular thing or in that way? You have mentioned it there like this. So just see the definition. Hey, Bharat agriculture purpose for definition. So the agriculture definition is so vast. When you are not specifying it, so somebody has planted some trees. ଆପଣ ଯାହା ଦେଖୁଛନ୍ତି ସେ ଯଦି କିଛି trees plant କରିଛି ସେ ସବୁ ଜିନିଷ କରିଛି ଗଛ ପଛ ଲଗେଇଛି ଏବଂ how do you say it in view of the definition which is there? ଆପଣ ଯଦି ଗୋଟେ specify କରିଥାନ୍ତେ କିଛି ଯେ ନାଇଁ ତମେ ଏଇ crops କରିବ ଆଉ କିଛି କରିବନି ସେ କିଛି ଲଗେଇଛି କିଛି ଜାଗା ଫାଙ୍କା ରଖିଛି ହୁଏତ ସେ ଆଉ କଣ further କରିବ. How do you say that here the lease condition has been flouted? We are only on that point. You have resumed it because it was not used for the agriculture purpose. It is lying fallow, but it is not actually lying fallow. There are some things over that land. Some plants are there, other things are there. Is it not the case that your inspection report also indicates that, Mr. Mukherjee? What is that report that it is not lying fallow? There are some.
Well, your lordship has seen that document. I will show to your lordship.
Before my lord, may not see your answers, I will take my lords to one more document.
Just a minute. Come to that. Be brief. I'm sure all of you are like it.
Your lordship has seen that. Your lordship has kindly see the date of that report. And now kindly take page 35 of the page 35 of the writ petition.
This report, Mr. Mishra, that is annexure 5, which they are relying on. Is different. Annexure 5, it is the report submitted by the Revenue Inspector Chandaka, your officer, to the Tahsildar Bhubaneswar. And
this is exactly my lord. That's what I was trying to submit. This is not with regard to in relation to this.
Same.
It relates to different WL case. That is the reason. We asked it to clarify that. Have you clarified?
That has not been clarified. That is why I wanted to see, bring that to your lordship's notice first.
Typically mentioned that the report which you are relying, case number is different. Mutation case is different.
Now this report, now disciplinary proceeding is being initiated against this person, man. Against this person who has issued this report. Disciplinary proceeding is being issued. My lord, it's already. It's already.
କାହା ବିରୁଦ୍ଧରେ କରିବେ disciplinary proceeding ଟା ଦେଖନ୍ତୁ ଖାଲି DFO issue କରିବେ revenue inspector issue କରିବେ ଆଉ କାହା issue କରିବେ
the WL case is same. This report which you have annexed in page number 45, please come to that page 45 and simultaneously open that annexure 5,
Ma'am.
page 28.
Ma'am.
Detail देखो. Annexure 45, you are relying, and they are relying on annexure 5, page 28 of it,
Yes.
right?
Right.
So in your report, the case number is same. You see, WL case number is 1278 of 1974,
Yes.
right? In connection with also WPC case number 3456, that is also same. This WA number, which is not there, REIT appeal number is not there. Mutation case number is different.
Yes.
In your case, it is mutation case number is so and so, and this it is mutation case number.
Ma'am.
My lords, may I clarify this position, my lords, for a minute?
Yeah.
Let me clarify this confusion. Both the mutation cases were registered for the self-same case. And this 314446 was dropped because mutation has already been allowed in that other case. This case was dropped. I have the certified copies of both the case records, which will show that identical orders were passed in both the cases. And this case, 31446 of 23, was dropped because mutation has already been allowed in the other case. And the report that my learned friend is relying upon so much, the DLC report or whatever, I will, Your Lordship, may kindly see the document.
Basically, on which RA report then this report on the challenge is passed.
I'm not on the basis of the report. I am saying that the order is perverse because it's not based on the material available on record. I'm saying the RA report says something and the Tehsildar has done something else.
This order challenged by you is in connection with mutation case number 5899.
5899, where my mutation was allowed. I am not challenging the mutation order. I am challenging that after
mutation order, basing on that, the present order has been passed, wherein the court has taken into account the early report and said that you are not in the purpose.
May I place it chronologically, my lords? It will be easier for appreciation because they are bringing in so many documents. That is what is creating the confusion. Your Lordship may kindly see just one.
Now, before my lord, senior starts, my lord, I will only show one more document and I will.
Yeah.
My lord, may I now take my lord to page 46. The POTA was issued in his favor. Now, this was also not shown to my lords. My lord, says page 46. POTA was issued in favor of Tilottama Bahinipati. Then my lord may kindly turn to page 47. The Kisam is Chota Jungle. So after this, we started DM Santos again because of Kisam Chota Jungle. Now this document ought to have been shown to my lords. This is my submission, and this order is appealed.
So what is the notation saying also correct that it was allowed. ROR was issued.
Yes.
And thereafter, on the basis of the resumption,
Yes.
that you have initiated.
Yes. Yes. So this order is appealed.
All right. Anything you want to further file, or we'll close this on this affidavit?
No, I will place the materials before Your Lordship. If Your Lordship wants, I can file a written submission.
File it.
I'll prepare a written submission and Your Lordship may post it to any other day because I would like to place the facts in chronology. Because in bits and pieces it has been presented to Your Lordship.
Submitted that he received the counter affidavit filed by opposite parties number 4 and 5 in court today, and the matter may be taken up next week. This matter on 18th September 2024. This counter affidavit is taken on record. Yes.
Item number 2.
Item number 2, Lordship. Similar set of matters was there on your Lordship board yesterday as item number 41 of the weekly list, my lord. Lordship was pleased to issue notice on that batch of matters, my lord.
Item number
41, my lord. 41 of the weekly list,
yes.
my lord.
My lord. Opposite part number 3.
Yes, 41 is order is to notice. So that say order for the that is to be listed along with a date with either say the order for the listed along with 2131-388 of 2024 for the
In this case, I am appearing for the opposite part number 3, ma'am.
Hard Mr. Partha Nayak and counsel appearing for opposite party number
3.
3. For the, so, item number 40, 41 of the previous. All right.
Obliged.
Item 3.
May I please?
Yes.
Here the petitioner has challenged the auction sale notice under Annex 1. The 13-2 notice has been issued, thereafter 13-4. Thereafter, the bank has so moto initiated a proceeding for settlement under Annex 6, page 25. The bank initiated before the court office of District Legal Service Authority, Borom. I appeared in that mediation fees I have deposited, the borrower has deposited. When the court has asked for deposit the mediation fee, the bank fled away. Thereafter, they issued the notice for public auction under Annex 7. I wanted to settle the matter before the District Legal Service Authority under Annex 6. The entire order sheet I have annexed. Thereafter, they issued notice on 20/6/2024. With reference to that notice, I filed representation before the bank authority to settle my loan dues. Thereafter, the Annexure 1 has been issued for auction of my residential house, which was mortgaged before the bank. 10 lakh is the principal amount. Now, as per their demand, that till today they are demanding 12 lakh sum.
When Annexure 1 is issued?
That I have obtained from the bank that document. The scheduled date of auction was 6/9 last week.
So
6/9/2024.
What happened on that day?
On that the auction held, but no final decision has taken.
Go to the appropriate forum. You will not entertain this alternative. Remedy is available, and the auction sale is also the auction date is over.
No sale certificate has been issued. No sale certificate has yet been issued.
Yes,
and my representation is pending.
So, and it is mentioned in paragraph number 1 that the auction sale of the mortgage property was scheduled to be held on 6/9/2024 as per auction sale notice under Annex 1. When we made a query to the land council for the petitioner, that what happened on 6/9/2024, land council on instruction submitted that the auction sale failed. Since it's an alternative remedy is available, we are not inclined. Since the auction is also failed, so we up to the petitioner to approve the bank for settlement, and he can also approve the alternative. So it's disposed.
I will be. My representation for settlement is pending with.
You approve the bank. We have stated that since now the this auction has failed, according to your statement, we do not know. On 6/9/2024, So
See, auction held on that date, but no final sale certificate.
there's not any document with you, and alternative remedy
Till that I may be protected my house.
go to the appropriate. Next,
Item number 4.
item number 4, my lord. Kindly pass over. Production of the appeal on the on the way. दिका होता था तो ठीक है escort ने
Item number 5.
सुनो लो Diciendo dicho que se tuvo.
Yes.
In lordship, this matter. Last lordship, can you remember my friend was appealing for appeal number 4 made a statement that they had filed a copy of the counter.
Your lordship
But-
called for the counter. It has come on to record, my lord.
And also, I have just now filing a reason to that lordship because yes, certain allegations,
By opposite party number. Yes.
and I have also served copy on them, lordship.
Serve the result.
But no, lordship, served copy.
I
lordship.
received the copy of the result.
What will you propose to? Whether we'll have just today itself or
Lordship.
we'll take up next week?
Well, I will go through the result and lordship call next week.
Tell us a date, any supplementary it can come.
My lord.
Next Thursday.
No, you all of you say that what
Next Thursday, lordship.
next Thursday,
Last day, lordship.
19th.
19, lordship.
No matter.
18.
Any day next week, your lordship.
18th.
18, lordship. Lordship.
Mr. Dole has filed rejoinder to the counter affidavit filed by the opposite party number 4 in court. Copy of the rejoinder affidavit has been served on the Land Council for the opposite party number 4. So also the opposite party number
Opposite bank, lordship.
opposite party number 2 and 3 the
Oh.
opposite party number 2 and 3. And counsel for the opposite party number 2.3, so also and counsel for the opposite party number 4 submit that they will seek some time to go through the rejoinder of the and matter may be taken up next week on consensus of all the parties. This matter on 18 September 2024.
Lordship.
This is taken on record.
Interim to continue, lordship.
Interim order.
Grateful, lordship.
Item number 6.
Item 6, my lord, I am challenging the order of the tribunal. I already
Change. You are appearing for opposite party number 1.
Just now, filing counter affidavit.
Go to it.
Just now, they have filed.
It's all right. If you want to file any rejoinder, you are.
Yes,
What time you are actually required to file?
3 weeks time.
Kindly be given, Your Lordship.
Yes. In that case, ma'am, she is the conducting counsel.
Oh.
But
All right. The counter affidavit has been filed on behalf of the opposite party number 1 in court. The opposite party number 1 now Antarjami Behera. Copy of the counter affidavit has been served on the learned counsel for the petitioners in court, who seeks 3 weeks time to file a rejoinder affidavit out of this matter on such and such date. What have you stated? Have you seen that order which we passed on 8/8/24?
Your Lordship.
So this submission that was made by the learned counsel, you have gone through perhaps that order dated 8/8/24.
Your Lordship.
That submission which was made, that this ground of non-supply of documents was neither raised before the appellate authority nor taken in the original application, and therefore the impugned order passed by the Central Administrative Tribunal is not sustained. That is the ground which. So we hope that
Yes,
you
Your Lord.
have answered it in your counter affidavit.
Yes, Your Lordship.
Okay. Take it.
Date, Your Lordship, short date may
Yes.
kindly be.
It will become 3 weeks. We'll see that date. You can in the evening check that website. You can get the date. And this interim order which was passed on such and such date will continue till next day. Okay.
That is already there for further orders, until further orders. Yes. Well,
Your Lordship. Oblige, Your Lordship.
Yeah. Buझे जाइतला. The moment he comes, and in that matter, we hope that you have contacted that advocate in that death reference case yesterday.
Yes, I wanted. He told that he is not filing any criminal appeal matter. He'll appeal in the JCR. The Uklama which he has received, he'll appeal in JCR.
What is the years of practice of that learning?
He is a practitioner of Bhubaneswar.
No, have you got any?
yes, given a backlog now on go.
Phone.
No, we have also asked him yesterday that if you interested that apart from that counsel, if you want that
Yes.
somebody else, a senior advocate also, so
That
he
he-
can
70
give them, so that both the learning council we has engaged, both of them.
He is appealing in JCR. Pilot can also
No, that is there in death reference case, we can engage that. That's we just wanted the names from him. So even if he does not give, we can in the death reference case, obviously we have to engage somebody else. So that is there. So just we wanted to know that how many years of
verify.
yes, come all the matters.
Weekly list, item number 64.
My lords, the petitioner name is not and listed in the survey list of affected family. The petitioner filed a representation before the opposite party number 5. Annexure 3
is there. Annexure 3.
pending. My lords, same model may be passed, my lords.
Okay. Right into the order.
Item 65.
My lords, item 69 also same.
69 same.
My lords.
All right.
May I please alert? The petitioner here challenges the annexure 6 page 20, the demand notice issued by the bank regarding payment of the outstanding dues of 3,50,000. Here is the case, my lord. I am the petitioner having a term loan in 2020 to purchase a bus of 37 lakhs. And till May 2024, he cleared the paid the installment.
What you propose to ask do here?
All of
We
this
will
was
calculate this. That what is your dues? What is the outstanding?
outstanding is 3,50,000, man. I am praying that since my boss has faced with an accident in May 2024.
The bank has issued a demand notice. If you
I'm not
you can file a representation before the authority.
I have represented on annexure 5/17 without considering they have issued. Initially they issued
They
the
have issued.
initially they issued the annexure 4,
No, after
page 16.
after this letter dated
They have not considered.
Mr. Counsel, after this letter was issued on 28/2024, you submitted an application on 21/8/24.
Yes, my lord. But that was not considered by the bank.
How do you know?
As because but I mean
Not got any response.
not any response.
Submitted sponsor application is on. So that is to be considered and result thereof to be communicated to the petitioner within 2 weeks from the date of production of the certified form. Yes, disposed.
But till then,
Also, no question of till then. Yes.
like
Item 66.
please, your lord. Whether the petitioner is an inhabitant of village Tuluk, which is coming under the earmarked area for Tiger Reserve project, which is sponsored by the Government of India. And as per the decision of Government of Orissa, Satkosia sanctuary was earmarked for Tiger Reserve project, my lord. The petitioner village being earmarked for that area.
What is your representation?
Well, representation as a annexure matter 6, page 25. Matter kindly see the page 23, matter.
Right, alert. We are directing for disposal. Yes, next.
Item 67.
The petitioner is challenging annexure 2 at page 21, in which the order was passed. At page 21, kindly have a glance.
Why will you entertain a order which was passed in 87 in 2020?
Because I have mentioned that the order was passed behind the back of the petitioner, as the father of the petitioner, and after cancellation, in spite of that cancellation of the lease, the father of the petitioner was in possession of the suit land, and the petitioners are in peaceful possession of the suit land. I have mentioned in para 7 at page 9 of the writ application that after death of the original lessee.
This order, first of all, as my esteemed brother pointed out, that there is statutory remedy available against the order passed. Number 2, 87 order you are challenging in 24. Not
Statutory provisions there. Because in similar cases, I have filed near about 15 to 20 cases. 4 cases are available with me. In 4 cases.
Just a minute.
And this Honorable Court has also passed order in 2 cases. In my case,
87.
Your Lordship kindly. This Honorable Court has passed order in 2 cases. And in 15 cases, exact same order was passed. No notice was issued, no opportunity was given, and behind the back of these petitioners, the order was passed, and in the issued order, even if it has been stated at page 21.
Mr. Counsel, we are making a submission. Please verify the order. It is mentioned in the paragraph number, subparagraph, that the opposite party, in reply to the so-called notice issued, submitted the written statement stating therein that this revision.
That is
How do
mentioned.
you say that the opportunity of hearing has not been provided? The revision has been filed, notice issued, and they appeared. All these things
Yes,
are considered. How do you say?
I will be pardoned to submit, my lord. This type of order, in as many as more than 50 cases, these orders have been passed, and in all cases, I have filed 15 writ applications before this Honorable Court, and all the records were called for. In the first para, the inquiry report of the SDO Bhubaneswar in this list indicates mistake of fact, fraud, misrepresentation, and material irregularity of procedure. No report is there, no notice was issued, and he has not appeared. But this type of report order was passed in so many cases. Let the record be called for, which I had appeared and filed so cause, then I have no case.
No explanation has been in the writ petition was as to why there is such an inordinate delay in approaching this. Inordinate delay is disposal or she can be entertained, dismissed. Yes, next.
Exact order of this Honorable Court I have submitted before the lordship. Exact order more than 25 or 30 years delay has been condemned in this case, and because of the order, the order was passed.
68.
My lord, very limited prayer, my lord. My OTS application is pending, my lord. Till disposal of my OTS application, my lord. No perseverance.
Your lordship, we have filed wakalat
13
now.
for notice you are challenging.
Yes, my lord.
Approve the approve.
My lord, now possession notice. My lord, I have
Yes.
challenged the possession notice.
Bank.
You. Are you filing Greenama?
We have already filed.
Your name is not there, madam.
On behalf of Nalini Kantas, I am
Nalini
presenting.
So on so is 13 for notice has been challenged. Alternative remedy available. We are not inclined dispose of. Yes, next.
Item 72.
Yes, 72.
Lord, item number 72. This case is covered by the Narottam Ratha judgment, my lords. Your lordship, similar order is also there. I am passing the similar order copy.
Order taking disposal for it.
Item 73.
Limited grievance of the petitioner. Applied for a settlement of land under the OGLS Act in pursuance to the.
You have given annexure 1.
Sir, that may be considered. That is my limited grievance.
The date of that date of representation not given.
No, this is recommended by the officially recommended.
No,
it is a school. School is applying for settlement.
No, you have mentioned in your prayer that for early action on the representation at annexure 1.
That is a mistake, my lord.
Annexure 1, we want to know the date. That is, it is not mentioned here. That is why. On what date this was? This is addressed to Tahsildar Patamundi online.
And he has acted also. He has prepared report for the report everything. But this application is in a format.
All right, obviously it is to be in the format. So
the date, my lord.
Date not given. And signature of the headmaster is there in below and with his seal. That is there.
No.
But no date is.
My date for consideration of this stipulated time as this honorable court deems fit and proper.
Annexure 1, stipulated time, the other one will be and the order be communicated. So, yes, dispose of.
Item 74.
Annex 8 minus Part of the liberty to consider the job, and he had that certificate to answer to the manner.
Where is your representation?
Representation is under answer 6 page 43 million.
That is dated 4/3/24. But the order has been already passed on 25/4/24. So, if the claim has been rejected, if you file a representation petition thereafter or again after that, then what would be? No, what we say that if that has been rejected, what is the way out? Whether it can be that can be addressed in a representation petition, or you are to approach some other authority. That is what the order is passed. This annexure 8 is the order. You come to the annexure 8. It is passed by the collector Moyurbanj. Now this order also mark the date on which the order has been passed. This order was passed on 25th April 2024. Right? Now you come to the operative portion, the finding portion. Let's read it out. Seti dekhon wizard. This is the part.
Item 74.
Page 49 bahar kar diyon.
49.
Annexure 8.
8. Well,
And page is 49.
Finding portion.
Yes, please read out that finding portion.
That the petitioner was a resident of the Summers village.
Might have adjust. Yeah.
That the petitioner was a resident of the Summers village, Sana Barakumunda. He was enumerated and approved as a displaced person under Deo Irrigation Project Koranjia. Thereafter, the petition has been resettled at Kalakada village under Potwil GP in Koranjia block. That in view of the resettled. That in fact the certificate for displaced person has been issued by the Special Land Acquisition Officer Deo Irrigation Project Koranjia on 24/6/2021 in favor of the petitioner, certifying that he shall be entitled to government services from local GP or block, etc., has been availed by his family in previous place of residence subject to eligibility in different schemes. That the certificate for displaced family was issued only to get the benefit under different government schemes at the resettled place, that is village Kalkada, has been availed by the family of the petitioner in their previous place of residence, that is Sana Barakumunda, subject to eligibility. There is no such provision for providing any kind of job appointment to the displaced person under the Orissa Resettlement and Rehabilitation Policy 2006. But they have availed other similarly situated persons have availed such benefit, my lord, under the Annexure 9 series. Annexure 9 says page number 53, my lord.
This come later, after filing of the read, probably it has come.
No, my lord.
This order was passed in pursuance to the order passed by this court in that writ petition. So the writ petition was disposed of and a direction was issued that the representation of the petitioner is to be considered. They have considered the representation and ultimately held that you are not entitled to get any government job, right? That is it. Right. So if you file again another representation and we'll pass the order that representation is to be disposed of, so whether the collector has got power to review its own order.
Notice was to show that taken from the counter, it will be decided on merits.
Your prayer is different. If your prayer is different, earlier you came for that file a representation disposed of. Now the authority has disposed of your representation and turned down your prayer. You saying that again I will file another representation.
No, I'm not telling this.
Representation of annexure 6 କହୁଛନ୍ତି ନା ଫାଇଲ କରିଛୁ ବୋଲି ସେ annexure 6 ର representation ଟା ହଉଛି ଏଇ order pass କରିବା ପୂର୍ବର
ଏଇ ଭିତରେ ଆମେ challenge କରୁଛୁ order ଟାକୁ. An application challenging order dated 25/4/2020 passed in miscase number 3 in rejecting the claim of the petitioner for appointment under R&I policy 2006.
So how do you say that in what way this order of this collector is wrong? The finding which he has arrived at
certificate issued under Annex 4, my lord. Similarly situated person under Annex 9 says having granted such benefit, my lord, but they have rejected my claim in the order.
Who have got the
Page 53, my lord.
53?
Annex 9 series, page number 53. My lord. My lord. My lord, paragraph 19, my lord.
Read out paragraph number 19.
That it is humbly submitted that similarly situated person like the petitioner.
Use the work. Annexure 19. Page.
Read petition.
Para 19, page 8.
That it is humbly submitted that similarly situated person like the petitioner are availed the benefit of government service through local GPR block in view of the certificate issued by the opposite party number 4, that is the Special Land Acquisition and Rehabilitation Officer Mayurbhanj. It is also submitted that similarly situated persons, displaced persons coming under Subarnarekha irrigation project and Kalo irrigation project subsequently merged with the Baripada irrigation division have got the benefit of appointment as per the notification dated 27/6/2013 issued by the Government of Odisha Department of Water Resources, but the petitioner has been discriminated.
Under the same irrigation project.
My lord. My lord. They have subsequently merged, my lord.
Who irrigation apono project under action Deo irrigation project.
My lord.
সেটা যেটা অর্ডারটা দেখিলে সেটা দেও ইরিগেশন প্রজেক্ট
সেটা Subarnarekha, my lord. But they are also the same displaced persons, my lord.
No.
Because somebody is a displaced person in a particular, they are governed in that different.
ତାର ଟର୍ମସ୍ ଆଣ୍ଡ କଣ୍ଡିସନ କଣ ଥିବ ୟାର ଟର୍ମସ୍ ଆଣ୍ଡ କଣ୍ଡିସନ କଣ ଥିବ ଆପଣ ଦେଓ ଇରିଗେସନ ପ୍ରୋଜେକ୍ଟ ର ୟୁ ଟେକ୍ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଓ ଇରିଗେସନ ପ୍ରୋଜେକ୍ଟ ର ଆପଣଙ୍କ ଭଳି ସିମିଲାରଲି ସିଚୁଏଟେଡ ପର୍ସନ ଯଦି କେହି ଏଇ ରିଲିଫ ପାଇଥିବେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଜବ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଇଏ କରିଥିବ then we will ask the state council to obtain instruction.
I'll take the instruction.
This writ petition has been filed by petitioner Rajat Kumar Naik, challenging the order dated 25/4/2024, passed in miscase number 3 of 2024 by the collector Mayurbhanj, opposite party number 3, in rejecting the claim of the petitioner for appointment under Odisha Rehabilitation and Resettlement Policy 2006 under Annexure 8. The collector, while rejecting the representation of the petitioner, gave the following findings. What findings are there? Page 49, 1, 2, and 3. The learned counsel for the petitioner submitted that similar persons have got the relief and he drew the attention of this court to paragraph 19 of the writ petition. So also to Annexure 9 series. However, the learned counsel for the petitioner fairly submitted that the projects are different, and so far as the case in hand is concerned, it relates to Deo Irrigation Project Karanjia. And he seeks time to obtain instruction as to whether any displaced family under the Deo Irrigation Project Karanjia has got the relief as has been claimed by the petitioner in the writ petition. What time you require?
After vacation.
After that. Could have released this matter after ensuing Durga Puja holidays.
No solution.
Item 75.
My lord, in this case, Annexure 1 is under challenge. My lord, in this case, 13 for notice. 13 for notice. Annexure 1. My lord, in Annexure 1, sale notice has been issued, and now auction has been finalized. In this case, my lord,
Yes, what
13-3. My lord,
13 for notice कौन है ला?
13 to notice Annexure 2. And
no, 13 for notice is sale and
yes, auction has been declared. Instead of finalized, what are the delivery position?
Approach
My lord,
alternate authority is there.
you
are appearing for
my lord, I may be giving liberty.
Aravinda Patna may be written. He is file
Mr. Aravinda Patna.
My lord, liberty may be granted to approach the
petitioner has challenged the to answer. It is stated by the learned counsel for the opposite party that yesterday the auction has already been finalized. Stop in view of the availability of the efficacy alternative in additional we are not approve the appropriate forum.
My lord, liberty may be given.
We have given the liberty to approve the appropriate forum.
Appropriate, my lord, to the bank, my lord.
The bank cannot do anything now. The person, if you get take the name who is that successful person, implead him as a party in that, then notice will be issued. Then if anything can come up, that would be seen. Otherwise, nothing.
Till then, no final decision over the sale may be given.
No, my lord.
Till then,
think you can get that from the other.
My lord, within time may be given.
Within time, we are not. We are just saying that alternative remedy you have to approve for your relief. Yes.
My lord, the 10 days may be given.
Item for supplementary.
Absolutely. जो एडवोकेट है से ये ऑप्शन ते माइक एडजस्ट करो से तक कौन से So please read that order, Mr. Tripathi.
Yes, ma'am.
We passed the order on 3/9/2024.
What lengthy order is there?
You come to that order. Let us know that. 3/9/24 order person.
Yes, ma'am.
Wacom replace करो. तो वाकम ऊपर से कागजटा रखिन के प्राइस एटो अच्छी ऑर्डरटा सर देखिन कोना 3
Yes, sir.
Please read their order.
This application was filed by the
Mic adjust करो दो.
This application was filed by the appellant petitioner Jata alias Sanatana Hessa for a reconsideration of the conviction order on the basis of the age factor and the setting aside the order of imprisonment for life passed by the learned trial court. That is additional sessions Talcher in CT in the case number 26 of 2015 by the order dated 4/12/19. When the matter was taken up on 15/7/24, we asked the learned counsel for the state to file objection, if any, to the interim application. On 30/7/24, the matter was listed, and on that day, the learned counsel for the state filed objection. Then the matter was taken up on 12/8/24, and we pursued the objection.
Peruse the objection.
Perused the objection filed by the state, wherein we found that the school transfer certificate, which was annexed to the interim application, was forged document, which is apparent from the school admission register and the report of the headmaster of Kathakumpa Primary School. Since the affidavit was shown in the interim application by Mr. Donardana Setti, advocate clerk, we directed to issue notice to the said clerk to show cause as to why a proceeding under the Contempt of Court Act 1971 shall not be initiated against him for swearing the affidavit in the interim application enclosing first document. Thereafter, the matter was taken up on 22/8/24, and Mr. Dhanardhana Setti, advocate clerk, appeared before this court in person and filed an affidavit wherein he stated that the concerned advocate prepared the affidavit in his name, and on being instructed by him, he sworn the affidavit wherein certain documents were enclosed, and that he had no knowledge about the genuineness of the document, and on bona fide belief and good faith, he carried out the instruction of the advocate, and there was no scope on his part to verify and examine the genuineness of the authenticity of those documents. On our query, the advocate clerk Dhanardhan Setti submitted that it was Nityananda Panda, advocate, who asked him to sign the affidavit, and accordingly, without going through the averment made in the interim application, he had signed the affidavit. We asked Mr. Nityananda Panda, advocate, to clarify the position as to from which source he got the document. He stated that it was the brother-in-law of the appellant who produced the certificate before him, and on good faith he annexed the same to the interim application. Accordingly, we directed Mr. Nityananda Panda, advocate, to file an affidavit in that respect, specifically indicating the name and details of the person who produced the fake school certificate dated 17/8/2009 before him, which was annexed to the interim application, and the date and place where it was produced. The matter was taken up on 27/8/24, and Mr. Nityananda Panda, advocate, filed an affidavit wherein he stated that one Gonia Gagarai, son of Shibo Gagarai, village Jagannathpur, PS Kuliari, district Anugul, who was the brother-in-law of the appellant Jotta alias Sanatana Hesa, handed over the school certificate to him, and on good faith he accepted the same to be genuine, and accordingly the same was annexed to the interim application. After perusing the affidavit filed by the learned advocate, we directed the inspector in charge, Kuilari Police Station, to produce Gonia Gagare before this court today. In pursuance of such order, Mr. Sanjeev Jal, ASI of Police Kuliari Police Station, Anugul, has produced Gonia Gagare before us today. When we made a query to him as to from which source he got the forced school transfer certificate and handed over the same to Mr. Nityananda Panda, advocate, he stated that his mother-in-law has handed over the same to him, and accordingly he produced the same before the learned advocate. It is prima facie apparent that Gonia Gagarai has produced the forced school certificate before Mr. Nityananda Panda, advocate, and accordingly, on the basis of such document, this interim application was prepared, and Mr. Dhanardhana Setti, advocate clerk, has sworn the affidavit in the interim application. The conduct of Gonia Gagarai prima facie attract the provision of the Contempt of Courts Act 71 and it comes under criminal contempt as per section 2C of the said act and warrants action thereunder as held in the case of Chandan Sasi versus Anil Kumar Verma reported in so and so Supreme Court cases. Accordingly, we directed to initiate contempt proceeding against Gania Gagare under the Contempt of Courts Act 71. Let him file show cause as to why he shall not punished under the provision of the Contempt of Court 71 for proceeding forged document before this court through his advocate. The show cause affidavit we filed within a week. Put up this matter on 12th September 24 at 2 p.m. Till the next day, Gonia Gagare be detained in jail custody. He shall be produced today before the learned SDGM Sadar Kotak, who shall pass necessary order for his detention. He shall be produced before this court on the next date. Mr. Nityananda Panda, advocate, and Mr. Dhanardhan Sethi, advocate clerk, shall also remain present at that date.
Sir, in your affidavit, you have never mentioned while filing before this court, because this court believed in you, you being the officer of the court. Nowhere in your affidavit you have submitted that it has been produced by that fellow. You took the entire responsibility yourself, and your advocate clerk has signed it. Now he also takes the responsibility, saying that I did not know anything and I acted in good faith. So one after another, you just went on shirking your responsibility without giving the responsibility of this man. So it comes to you, it comes to him, and this fellow has come later on when the responsibility was given to you. You filed a affidavit saying that I got it from you, but that is not your averment in the first affidavit. That on being procured by my client, the document has been produced. This is not the case. So primarily, you have responsibility, and you understand. We never know this fellow. We know you, and the manner in which the document was procured and the purpose for which the document was also placed was for the release of a person from this person
who has been sentenced to life imprisonment, and you are filing a document that he is a juvenile, so therefore his conviction should be set aside. Seriousness of the matter is there.
My lord, it's extremely sorry.
You are not a novice, mister. You are in practice for how many years? What is your enrollment number?
36.
30?
99. Almost 99.
99. ତମେ ଇଆଡକୁ ଆଗକୁ ଆସ। ଏଇ ଯୋଉ ଗତ ଥର ଯେତେବେଳେ ତମକୁ ଡିଟେନସନ କରିବା ପାଇଁ ଦିଆ ହେଇଥିଲା ଏବଂ କୁହା ହେଇଥିଲା ତମକୁ କାହିଁକି ଦୋଷୀ ସାବ୍ୟସ୍ତ କରାଯିବନି କଣ୍ଟେମ୍ପ୍ଟ ଅଫ କୋର୍ଟ ଆକ୍ଟ ରେ ତା ପାଇଁ ଶୋ କଜ ଦାଖଲ କରିବା ପାଇଁ, ତମେ କୌଣସି ଶୋ କଜ ଦାଖଲ କରିଛ କି?
ଆଜ୍ଞା ତାଙ୍କର ତ ଯେ ତାଙ୍କ ଯିଏ ଦେଇଥିଲା ଆଜ୍ଞା ତାଙ୍କ ମା ଯୋଉ ମୋ ଶାଶୁଘର ତାଙ୍କ ମା ତ ଡେଥ୍ ହେଇଗଲେଣି।
ଶୋ କଜ ଫାଇଲ କଲଣି ନା ନାହିଁ?
ତମକୁ ଶୋ କଜ ଫାଇଲ କରିବାକୁ କୁହାଯାଇଥିଲା, କଲ କି?
ତମକୁ ଜବାବ ଦବାକୁ କୁହାଯାଇଥିଲା। ତମକୁ ଆଇନ ଅନୁଯାୟୀ ଯେତେବେଳେ ଜଣକୁ କୌଣସି ଅର୍ଡର ପାସ୍ କରିବାକୁ ତାକୁ ଗୋଟେ ଅପରଚ୍ୟୁନିଟି ଦିଆଯାଏ, ତେଣୁ ତମେ ସେଇ ଯୋଉ ଆମେ ସେଦିନ ଅର୍ଡରଟି ପାସ୍ କଲୁ ଏବଂ ଆଜିକି ରଖିଥିଲୁ, ସେଥିପାଇଁ ତା ଦେହରେ କୁହାଯାଇଥିଲା ଯେ ତମେ ଶୋ କଜ ଦାଖଲ କରିବ। ତମର ଜବାବ ତମେ ରଖିବା ପାଇଁ କହିଛନ୍ତି, ତମେ ଜବାବ ଦାଖଲ କରିଛ ନା ନାହିଁ?
ନାଇଁ ଆଜ୍ଞା ମୁଁ ତ କିଛି ବିଷୟରେ ଜାଣିପାରୁନି, କଣ କିଛି ମୁଁ ଜାଣିପାରୁନି କିଛି।
ଆମେ ପୁରା ଓଡିଆରେ କହୁଛୁ, ଜବାବ ଦାଖଲ। ତମେ କୌଣସି ଆଡଭୋକେଟଙ୍କର ସାହାଯ୍ୟ ଦରକାର କି? ଆମର ଏଠି ଲିଗାଲ ଏଡ୍ ହାଇକୋର୍ଟ ର ଗୋଟେ ଲିଗାଲ ଏଡ୍ କମିଟି ଅଛି, ଯୋଉଥିରେ ଫ୍ରିଲି ଆଡଭୋକେଟ ମଧ୍ୟ ଆପଣଙ୍କ ପାଇଁ କରିପାରିବେ, କିଛି ଅସୁବିଧା ନାହିଁ। ଶୋ କଜ ତିଆରି କରିବା ପାଇଁ, ଆଫିଡେଭିଟ କରି ଦାଖଲ କରିବା ପାଇଁ ଆପଣଙ୍କୁ ସାହାଯ୍ୟ କରିପାରିବେ। କିଛି କହିଲନି ସେଦିନ ନା, ଆଜି ଫାର୍ଷ୍ଟ ଟାଇମ ଆସି କହୁଛ। ଆମେ ସେଦିନ ତମକୁ ଯେତେବେଳେ ପଠେଇଲୁ ସେଦିନ କହିଲୁ ଯେ ଜବାବ ପାଇଁ ଗୋଟେ ସପ୍ତାହ ଟାଇମ ଦେଲୁ। ଆଜି ଆପିୟରାନ୍ସ, ଆଜି ପ୍ରଥମ ଥର ଆସି କହୁଛ ଯେ ନାଇଁ ଆମେ କିଛି।
ଆଜ୍ଞା ଟିକେ ଯୋଗାଡ଼ କରିବି ଆଉ।
କଣ ଯୋଗାଡ଼ କରିବ?
ଓକିଲକୁ ଯୋଗାଡ଼ କରିବି।
ଆଡଭୋକେଟ दरकार कि आमे कहिबु हाईकोर्ट लीगल एड सर्विसेज
आज्ञा।
आपन को एडवोकेट जने
आज्ञा
प्रोवाइड
दरकार।
करिए बेली
आज्ञा दरकार।
ताहले आपन जवाब टे देबे
आज्ञा दरकार।
ए मैटर को एटा गोटे वेरी सीरियस मैटर आमे आउथरे ओडिया रे कहूछु एटा
आज्ञा।
आमे गंभीरतार सहित नैचु
आज्ञा।
कारण तम शला को आजीवन कारादंड रे दंडित करा जायतिला हत्या मुकदमा रे तमे गोटे जहा एपर्यंत आम पाखरे आछि बा जहा एडवोकेट माने एडवोकेट कहउचंती तमे गोटे से पिलार आ तम शलांकर गोटे सर्टिफिकेट आनिकिनी तांकू देलो एवं तारी बेसिस रे से गोटे पिटिशन फाइल कले जे मो शलार ए सॉरी आपन शलार बयस होउची सेतेबेले सी 18 वर्ष रु कम थिला तेणु ताकू दंडादेश जो हेची सेटा ठीक नुए आईन अनुଯାयी ठीक नुए सेटा काटी दिया जाउ से दंडादेश हला किंतु देखा गला जे से भली कोनसी जो स्कूल देइथलो से भली स्कूल रे से पिला पढ़िनी कि से जो सर्टिफिकेट मध्य से हेडमास्टर सेटु इश्यू करिनी तेणु से संक्रांत रे हेडमास्टर रो रिपोर्ट आईआईसी आनिले एडमिशन रजिस्टर रो कॉपी आनी प्रोड्यूस कले गुडो तो जणा कला जो ट्रांसफर सर्टिफिकेट टी आपण आनिकिनी आपण को वकील को देइथिले सेटा गोटे जाल सर्टिफिकेट तेणु एथिपाई अदालत आपण को दोषी साब्यस्त कहीं न करी कहीं दंड न देव एथिपाई आपण को शो कज दाखल करने को निर्देश होता गत तारीख रे तेणु वर्तमान आपण कौन चाहूँ आपण को आईन सहायता दरकार कि
निहाती सारे दरकार
अच्छा तो आमे एटा को आज ऑर्डर करूछु तो ऑर्डर करूछु हाई कोर्ट लीगल एड सर्विसेज अथॉरिटी आपण को आज ही गोटे एडवोकेट से ये करिवे आपण तांको यदि परामर्श आज हेई पारला न से एडवोकेट यदि समय मागिले तांको जहा आपनकर कहिवार अछि जे सर्टिफिकेट कोठो आसिला कोन हैला को प्रेस रे छपेई कि आनिले सब जिंस आमे तदंत करी हला तेणु से आपण कहिबे सो कज रे देबे एटा एमतिया केतेटा सर्टिफिकेट आउ कोडी प्रोड्यूस करछन
नाही आज्ञा
प्रथम थर पई प्रोड्यूस
एटा सारा मुई विषय जानि न
गार कारखाना गोटा अछि बोधे
आज्ञा
गार गोटा कारखाना करछ छापा खाना
नाही सारा विषय मुई जानि सारे
दांत देखौछ
नाही आज्ञा सत्तर को आज्ञा एटा मोर प्रथम विषय मुई जानि एटा खाली डुप्लीकेट ई कोन मुई विषय किछि आज्ञा जानि नथले
all right in portions of the order dated 3/9/2024 Mr. Nityananda Panda advocate, Mr. Dhanardhan Sethi advocates cloth are present. Mr. Gonia Gagarai was also produced from jail custody. As per order dated, as per the aforesaid order for this, we gave opportunity to the Gania Gograi to file so as to why he shall not be punished under the provision of Contempt of Courts Act 1971 for producing forged document before this court through his advocate. And the so cause affidavit was directed to be filed within a week. Gonia Gograi has not filed any so cause affidavit. And he seek the assistance of an advocate for preparation of the so cause. Since he's expressed his financial inability to engage an advocate, let an advocate from the High Court Legal Aid Services Authority engage an advocate and make availability of interaction of the advocate with the Gania Gagrai for preparation of the so cause. Order be communicated forthwith to the Legal Services Authority and the High Court Legal Services. matter be placed on 19th of September 2024.
The previous orders and the affidavits may also be supplied to him, the advocate, so that he, legal aid advocate, so that he can prepare the.
Okay.
The
Acha, the order passed by this court, सब गुड़ाक दे दो उसका, right from हमें the प्रथम order टा केवे pass होला, नहीं ता पूर्वुरु जेतोला में से प्रथमे on the ground of inspection to state has filed objection ता पूर्वुरु असला, interim application has been for setting asset on the ground that in support of so and so. He has also let the ground submitted is not having the copy. Acha. From the order dated, all the orders passed in connection with the this interim application from 15/7/2024 be handed over to the Gonia Gagrai immediately. And the same also be sent to the legal aid. So you बुझिलो एक यार दीटा सेट बाहर कर देवे जो from the order dated जो केते डाकिलो में केवल 15/7/2024 ହେଲା order number 12 ହେଲା ସେଇଠୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଆଜିର order କୁ ମିଶେଇକି ଯେତିକି order pass ହେଲା ତାର ଗୋଟେ କପି ତାକୁ hand over କରିବେ ଆଉ ଗୋଟେ କପି legal aid କୁ ଯିବ ଏବଂ legal aid ଆଜି along with 2 days order କରିଦେବେ.
so the affidavit filed by the Nityananda Ponda.
Acha, right, you are right. The affidavit filed by से जो advocates clerk जो affidavit करचंती तार गोटे कॉपी आईए रो गोटे कॉपी हला then the advocate जो affidavit नित्यानंद पंडा तांकर affidavit रो कॉपी ये सब गुड़ा को दे दे तांको भी देवे तीन petitioner दिवे एवं legal aid पठाओ हला so advocate clerk affidavit प्रथम आसिला तापरे अच्छा स्टेट गोटे रिपोर्ट देइथिले तार मध्ये कॉपीटा देबे रिपोर्टटा स्टेट रिपोर्ट देइथिले जे फर्स्ट डॉक्यूमेंट बेली से रिपोर्टटा
affidavit टा दिए
affidavit है
yes objection affidavit
objection affidavit तार कॉपी मध्ये दे देबे हला तो गोटे फाइल करी कि नहीं तांको दे देबा एठी पठेइ दन हला एटा
flag F
lagi na
lagi cannot if a matter of 19 तारीख को हला हां 10:30 19 10:30 10:30 19 तारीख सो से बाबू को आपण टिके अपेक्षा करथांतु से जो डॉक्यूमेंट गुडा का में दबु तांको गोटे सेट दबु आ गोटे हाई कोर्ट रो जो लीगल एड सर्विसेज अथॉरिटी अछि तांको पाखु गोटे पठेबु से माने जने एडवोकेट को आजी तांको पई केस लड़ीवा पई गोटे एंगेज करिवे सेटा फ्री ऑफ कॉस्ट रे हबो सी जहा कहिबे तारी बेसिस रे सी जवाब प्रिपरेशन करिवे एवं दाखल करिवे तार कॉपी दिया जीवो एमान को सब से अलगा कथा किंतु सेथि पई आपण टिके अपेक्षा करन कारण ए ऑर्डर से टाइप हबो टाइप होला परे से सब तक ऑर्डर रो कॉपी जेरॉक्स हबो जेरॉक्स ही तम हैंड ओवर करा जिवो हैला अच्छा लिखि दो till the next date this petitioner is to be detained in so custody हैला is remanded so तुमको वर्तमान 19 तारीख रे नेक्स्ट तारीख रहिला आज जो वकील बाबू जो एंगेज हेबे तांको सब जहा कहबा कथा कहबे जवाब दाखल करिवे एवं 19 तारीख दिन पर्यंत तुमको पुणी आउ थरे डिटेन रहिया को पड़िबो हला बुझिले ठीक है
चलो
तेरा ये शीघ्र टाइप करिवे and on that day this advocate and this advocate's clerks are also remain present.
76.
Yes,
OT list item number 76.
we are just coming. Just we are coming within one.
$7.6 ଅଛି।
Item number 76.
May I please, Your Lordship? Lord, against the order of Granite Central Administrative Tribunal, this writ petition is filed. Order is at page 190, Annexure 7, my lord.
Yes.
ଏଟା କଣ ଯାଉନି କି ରେ? Lord, Your Lordship, kindly turn to page 197.
Perform use for
197. Your Lordship, may kindly turn to page 197.
Yes.
Last line, last paragraph. In view of discussions made above and settled position of law, this tribunal does not find any ground to condone the delay. Hence, the MA is dismissed and resultantly, OA stands dismissed. On the ground of limitation, my MA was dismissed and OA was dismissed.
What was your prayer in the?
Exactly. My prayer was that in the year 2003.
Come to your first paragraph.
Of this order, Miller?
No. This 190, that impugned order.
Yes, Miller.
First paragraph is page 190.
Yes, Miller. That is, the applicant challenging the inaction of the respondent in not regularizing his service, even though he was designated as a casual laborer since 1/8/1996, and similarly placed persons have been regularized, has filed a way paying the following reliefs. Let the action of respondents be declared as illegal and arbitrary. Let direction be issued to the respondents either to lift the abeyance order via letter dated 4/3/2004 or implement the order of regularization via letter dated 3/10/2003, extending the equal treatment as has been indicated in para 4 above. Let a declaration be made that the abeyance order dated 4/3/2004 issued by the corporate office is no more a bar in regularizing the applicant against the post he is holding. Let a direction be issued to the respondents to regularize the applicant against the post of assistant telecom technician previously named as regular Mazdur with effect from the respective date of his joining in his service, and he may be given all the consequential service benefits attached to the said post. Let the applicant be granted with any other relief.
So, you were designated as a casual laborer in 96.
Then the policy decision was taken by the BSNL headquarters.
Yes.
And on the basis of that, 3/10/2003, they have issued one scheme that these are the persons will be regular.
In 2004, an abeyance order was issued.
Yes, my lord.
So, if an abeyance order was issued in 2004, you are challenging that order in 2022, 18 years delay.
Every day we are suffering. It is a continuous cause of action. My humble submission, for a moment, your lordship, may kindly turn to page 66, my lord. Page 66. Page 66.
Yeah.
That
is the regularization order is there.
Your lordship, kindly similar. Reference is invited to your letter number such and such regarding information of left out cases of regularization of casual laborers of your circle. The matter has been examined and it has been decided to regularize these left out PSM and CLH who were covered under the letter number such and such dated such and such. The information received from your circle has been accordingly scrutinized, and 455 TMS CLS serial number 1 to 455 have been found eligible for regularization at this stage. The remaining 982 cases of CLA are not found to be eligible for regularization. Well, so far as 982 persons are concerned, they approach to the Law and Tribunal, so also this Honorable High Court.
When did they?
Then,
When did they?
way back in 2003-4, Your Lordship may kindly see the next page. Because of the pendency of the case, they have kept it in abeyance. Your Lordship, page 67. I have given the type copy also. 4/3/2004. They have said, since the various litigations are pending before various courts of law, therefore this order of regularization is kept in abeyance below.
Where they have stated?
Last line, Your Lordship may kindly see. Last paragraph. In the light of above, it is once again reiterated that suitable cut-off date may be fixed for receiving the representation of consideration of the purpose. A wide publicity may be given for the said date. Just above, may I place other part also. The cases are pending before the CAT, and the Honorable CAT has directed to take the further steps that has been indicated above. Here they have said the process of regularizing 455 casual laborers for which the circle was authorized to create 455 posts in the basis of report received duly certified by the CGM IFA of the circle may be held in abeyance till these representations are finalized as per the order of the Honorable CAT. But they have not taken any decision till that year. It is a matter of regularization, and policy decision has been taken by the headquarters of it. And every day, it is a continuous cause of action. Every day the cause of action is there to get the regularization.
Wait. So, suppose you also submitted a representation.
Yes, no, my lord. We have been empaneled. That headquarter already recommended our name for regularization. They issued that kept in abeyance order, and on the guise that various proceedings are pending, and we are considering their representation.
Please follow the question and answer. This order which you are referring to, that is order dated 4/3/2004. So, in the last sentence, it is stated that the process of regularizing 455 casual laborers. You are one among them, right?
Yes.
For which the circle was authorized to create 455 posts on the basis of the report receipts. May be held. Maybe it was to
may be held in abeyance till these representations are finalized as per the order of the Honorable
what are the representations?
Representation that left out persons, 982 persons, those who have been left out, they approach to the Law and Tribunal. There the Law and Tribunal directed that they will submit the representation which will be considered. Therefore, headquarters New Delhi has taken the decision. The persons, those who have been left out, they may be asked to submit the representation. Till the representation and decision is taken on their representation as per the CAT's order, then this order of regularizing 455 will be kept in abeyance.
So you must have submitted a representation also?
Not they. They left out.
Left out only
455. Your case has already been taken for
regularization.
And the left out were supposed to file the representation.
And so when that representation which was filed by them, that was finalized.
That is not within our knowledge, and that has not been, according to us, that has not been finalized within. And we are going to return. And it was kept in abeyance for without any reason. They have already taken the policy decision, and committee was formed. They have considered and directed for regularization. Now, every day cause of action arising because it is a continuous cause of action. Regularization every day we can expect that will be regularized. But Law and Tribunal rejected by saying that why you have not pointed out that point of time.
Those left out persons, 900 something, whatever you say, after the submission of the representation,
Yeah.
Even though it has not been considered,
Yeah.
they are still continuing.
Yes, but everybody is continuing. Everybody, it is a matter of regularization. Casual, we are still continuing as casual, Mila. And they are also continuing.
That is how you seek for regularization.
Yeah.
You are casual, that is.
They are also continuing as casual. But their cases were not considered because there was a cutoff there.
Yes, yes. 98 was the cutoff.
Yes, Mila. Therefore, those who have been appointed prior to that, they will be regularized. After that, they will not be regularized. Here, Mila, the Lorna Tribunal only quoted the DCS Navy case and came to the conclusion that.
Come to the paragraph number 9.
Paragraph 9 of Mila.
Page 194.
Yes. 90.
194.
Mila.
Paragraph 9.
It is seen from the above.
Above order.
It is seen from the above order that Honorable High Court had decided not to issue any orders of regularization claims of the applicant and had observed that BSNL should take steps for claim of regularization. The cause of action for applicant had arisen back in year 2011 when the respondents have not taken any steps after the order was issued. No documents have been filed to show that the applicant had approached the respondent or any other competent forum ventilating his grievance. He slept over the matter for 11 years since 2011. The applicant could also have taken steps when the Pitambara Nanda and 40 other employees were regularized in 2017.
No.
He slept for
More than 5 years.
more than 5 years and approached the tribunal in the year 2022.
Yes, that was being questioned. That is why.
My humble submission, Pitambara, it is a policy decision. Policy issue, it was decided that 455 persons will be regularized. They have regularized some persons and left out other persons. Your Lordship is our that. Your Lordship, kindly, I have relied upon 3 decisions and including the Lorna Tribunal's decision is at page 198. Out of 6 cases, 1 case, same Lorna Tribunal has already condoned the delay and matter is ready for hearing, that place for hearing. And so far as other 5 persons are concerned, this original application was dismissed by the coordinate bench. Other judges, when the another learned
Yes, which decision you have?
Your Lordship may kindly turn to from the brief 198 also kindly turn. 198.
No, there's if you come to this decision which you are saying.
This I am relying upon 2 decisions which also I have relied upon before the Learned Tribunal, and he has not taken into consideration and not discussed anything. This decision, my lord, this is reported in AR 1979 Supreme Court 1144, my lord. Paragraph 2. May I please, my lord?
Yes.
We do not think that this is a fit case where we should proceed to determine whether the claim of the respondent was barred by Section 110 of the Madras Port Trust Act. The plea of the limitation based on this section is one which court always looks upon the disfavor, and it is unfortunate that public authority like a port trust should, in any morality and justice, take up such a plea to defeat the just claim of the citizen. It is high time that governments and public authorities adopt the practice of not relying upon the technical pleas for the purpose of defeating legitimate claims of a citizen and do what is fair and just to the citizens. Of course, if a government or a public authority takes up a technical plea, the court has to decide it, and if the plea is well founded, it has to be upheld by the court. But what we feel is that such a plea should not ordinarily be taken up by a government or a public authority, unless, of course, the claim is not well founded and by reason of delay in filing it, the evidence for the purpose of resisting such a claim has become unavailable. Here it is obvious that the claim of the applicant was just claim supported, so far as that case here it has been said. And another decision I am relying upon, This is my lord civil appeal number 4134 of 2024. Your lordship may kindly turn to page 10. Page 10, my lord.
Yes.
Accordingly, my lord. Accordingly, in Tarsim Singh, it has been held that principle underlying continuing wrongs and recurring successive wrongs have been applied to service law dispute. A continuing wrong refers to a single wrongful act which causes continuing injury. Recurring successive wrongs are those which occur periodically. Each wrong gives rise to a distinct and separate cause of action. Having held so, this court, Tarsim Singh, had further elucidated some exceptions to the aforesaid rules to the following words. To summarize, normally a belated service-related claim will be rejected on the ground of delay and laches or limitation. Or limitation. One of the exceptions to the said rule is causes relating to a continuing wrong. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in the respect of any order of administrative decision which related to or affected several others also, and if the reopening of the issue would affect the settled right of third parties, then the claim will not be entertained. For example, if the issue relates to the payment of refixation of pay, pension, relief may be granted in spite of delay as it does not affect the rights of third parties. But if the claim involves issuing relating to the seniority or promotion affecting the others, delay would render the claims stall and a doctrine of laches limitation will be applied. In so far as the consequential relief of recovery of arrears for the past period of concern, the principle relating to the recurring successive wrongs will apply. As a consequence, the High Court will restrict the consequential relief. They are the relief from which date that will be granted. But here, even if that benefit will be granted to me, that is not affecting any third person here. Because the policy decision they have already taken that 455 persons will be regularized. And out of those persons, they have already regularized some persons. And they should not compel all the persons to come to the court and to take the order.
In any case, it is a process they have initiated which has been kept in abeyance. The process is only to be initiated.
Yes,
that is all nothing more than that. No. But you come to that paragraph 9. How do we meet that? When others could agitate the matter, what made you not to go along with them?
My lord, my humble submission, this paragraph 9 relates to the case filed before this Honorable High Court seeking regularization on the basis of Uma Devi case.
No, they got regularized or not?
No.
They have not been regularized.
No, the only direction was issued, they will consider Mila.
That is there.
That is, they will consider Mila. So far as Mila, other persons from that panel, they have that list, they have given Pitambara number Mila.
No, 194 page.
Yes, Mila. The Honorable High Court had decided not to issue any orders of regularization claim applicant and held observed BSNL should take steps for claim of regularization. But this is in respect of that the person, those who have approached directly to this Honorable High Court, claiming the regularization under Uma Devi case.
No, all right. They still are holding.
Yes, Mila.
And they are within this 455 or left out?
Within the 455 left out, mixed Mila. They came because that was kept in abeyance. Some persons came and approached this Honorable Court that we have already completed 10 years. Therefore, the regularization be made in view of Uma Devi case. This Honorable Court did not pass any order, and it matter was sent back.
No, that is within the domain of the authority.
Yes,
have to say
regularization, Mila, and every day cause of action is arriving.
How many other cases are pending before this court?
Before this Honorable
right now, only this case.
I have filed out of 6 cases, Law and Tribunal dismissed 5 cases. 1 case is there. Therefore, I have filed 5 cases.
So what happened in those?
No, sir, it's the first case as it is. For the first time. Two cases are there. 61, 90, 76 and 77. Well, it is a regularization. Once it is rejected for lifelong, we cannot claim anything. Below. So far as other states are concerned, same policy they have already given the regularization.
Petitioner M. Dharma Rao has filed this writ petition challenging the order dated 15/7/2024 passed by the London Central Administrative Tribunal in MA number 405 of 2022 in OA number 146 of 2022. In dismissing both the MA, so also the OA on the ground of limitation. The Land Council for the petitioner submits that the petitioner was designated as a casual labor since 1/8/1996, and similarly placed persons have been regularized. And in view of the settled position of law as held by the Honorable Supreme Court in the case of Madras Port Trust versus Himanshu International, reported in 1144, and in the case of Rusibhai Jagdish Chandra Pathak versus Bhavnagar Municipal Corporation, passed in civil appeal number so dated so, the petitioner's case should not have been rejected on the ground of delay. Issue indicating therein that the matter shall be disposed of at the stage of admission. Anybody is appearing for Union of India?
I am appearing for Union of India. Well, I am appearing for Union of India.
Yes.
Well,
So-
I am.
Yeah. No.
My-
Or you will appear for all the opposite parties.
Well, it's
Have you
technically.
solved a copy on this one?
Yes, well, I have received the copy, but for BSNL has a separate panel. We need to take instruction from BSNL. So another one set of extra copy may be served.
Mr. There submit that he has received a copy of this also, and will make appearance of for all the opposite parties after taking instruction from BSNL authorities.
Yes.
List this matter after 4 weeks. Counter affidavit, if any, we filed in the meantime, giving copy to the Land Council for this one. Yes.
Next matter is same.
Your relevant paragraph would have been so and so in paragraph number 2 and so and so decision in paragraph number 1. See, you are addition that the report is citation.
May I give numbers of other two matters, similar matter. Same order.
77 is also same. So notice.
With my lord's permission, other two matters number may I give? For this?
No, you give the memo, it will be listed.
Public.
Item 78.
Petitioner challenge the impugned notice, possession notice under Annexure 3 at page 28. And the fact of the case is that petitioner has availed a loan of 21,30,000 in the year 2021. And
he had repaid near about 3 lakhs towards the loan interest. Thereafter, during the COVID period, his business was so affected and he was a defaulter. And let kindly see Annexure 2, page 22, on dated 16/12/2023.
Notice you have challenged.
13.2 notice issued.
13.4.
My
This
lord.
possession notice 13.4.
My lord.
Annexure 3 you are challenging.
Annexure 3.
So go to the alternative.
Let liberty may be given.
Disposed of. Yes, next.
My lord, no coercive action as per the.
Oh, sorry.
Item 79.
Yes, item 79, Avinash Parjoshi.
Please, Your Lordship. My lord, the matter is covered under your lordship's judgment. That is under Annexure 2, page 15.
So same thing. Annexure 2 रे जो Annexure 2 रे अच्छी same similar order. Yes, disposal.
Please, Lordship.
Item 80.
What is your good name, madam?
Mona Lisa Ghosh.
Give your name in it.
Item 80.
Item 80. So I'm the secured creditor. 13.2 and 13.4 we had issued and we had preferred an application under section 14. That is pending disposal before the CJM. Pray for is the expeditious disposal of that application as the statute provides 30 days. And it is the law is settled in.
What is the date of your application?
The date of my application is 18/6/2024. 2024.
The petitioner in the petition wait for a direction to the Chief Judicial Magistrate for the opposite party. You are seeking a direction to whom?
It's seeking direction to the CJM, but I cannot make the court as a party. So,
Chief Judicial Magistrate to expeditiously dispose of Bank MIS case number 98 of 2024 under section 14 of the Surface Act 2002 within the statutory period prescribed under the Act. The Land Council for the petition drew the attention of this court to Annexure 1, which is dated data for the
18/6/2020, page 18.
Page 18.
18.
18/6/2024. He submits that the Chief Judicial Magistrate is supposed to take action within 1 month.
Within 1 month, sir. Given the judgment.
Within a 1
month. It's ministerial job and Surface Act
provision 14 law.
Proviso. Second proviso provided further that if no order is passed by the Chief Notable Magistrate or District Magistrate within the said period of 30 days for reasons beyond his control, he may act for according reasons. In writing the same, pass the order within a period not exceeding 60 days. Proviso to 1, subsection 1.
This is second proviso.
Second proviso.
Second proviso to subsection 1 of section 14. Has not disposed of the, has not taken any actions on. He has relied upon the decision of also. Which are the paragraphs?
There are 8.1 minutes.
Page number?
Page number is 8. It's at the bottom.
Eight. Also, in view of the limited nature of grievance of the petitioner, this writ petition is disposed of directing the Chief Judicial Magistrate Kurga in bank case number so and so take a decision on the petition filed by the petitioner under Annexure 1 within a period of 4 weeks from the date of production of the certified copy of the order along with the copy of the writ petition. It is made clear that we have not expressed any opinion on the merits of the application filed by the petitioner under Annexure 1. Yes.
May I just please one thing, Milits? It's that this particular Milits, the application which we are filing before the learned magistrate, so it's a ministerial work.
You have to comply 14.1b. Your application is not in accordance with 14.1b.
That is to be verified whether everything that may ask you to file some other particular.
That we have already done, Milits, and that
it is not to be mechanically ordered.
Milits. Yes.
Item 81.
The petitioner participated in an auction of property which was auctioned by the bank for realization of the bank dues. But he became the highest bidder and directed to deposit. In course of time, according to their orders, total deposit was made on 30/4/2016. 30,25,000 was deposit. But thereafter, it happened that the bank came to know that a portion of the land which has been sold is involved in acquisition by the Sewerage Board. So I made a prayer that you commensurate the part, take out that part, but they did not answer it, went for another 2 auctions. All the auctions failed thereafter. But lastly, the auction was again held on 24/3/23, wherein the petitioner's wife became successful. The prayer was made to adjust the amount deposited by me, by the petitioner, and accordingly it was done. Sales certificate was issued. Now, the only point which I ask before your lordship is that retention money, if they retained it, they are supposed to pay interest on that. That has been decided by the Honorable Apex Court also.
We are appearing for Punjab National Bank.
Yes, Lord.
Okay. So,
last page, the lordship says, subparagraph 4, IV. Para 12 IV. Last page, we could have considered awarding 24% per annum compound interest on the auction money to be refunded to the applicants in view of the serious illegality committed by the bank in conducting the auction, driving the parties to litigation. Considering the fact that the money of the bank is also public money, we feel that interest of justice would be best served if auction money with 12% new compound interest is returned to the applicants. Such it will calculate from the date of field till the date actually paid. So only for that period I am claiming the interest. Which they retained.
Which Mahatma and senior advocate appearing for the petition. The petition has been filed by petitioner Sumit Mahanti for a direction to the opposite party. The interest on the petitioner's deposit of rupees 30.25 lakhs made on 34/2016 till the same was adjusted on 28/10/2023 at the rate of 10% per annum with quarterly rates. Mahanti relied upon the decision of the Honorable Supreme Court in case of Govind Kumar Sharma and another versus Bank of Baroda, reported in 2024 SCC Online SC 559 in paragraph number 12 bracket Roman 4, wherein it has been held as follows for that paragraph. Issue notice on the question of admission indicating therein that the matters are being disposed of at the stage of admission. Mr. Ramakant Mahanti visited filed his your appearance. Mr. Anjan Kumar Biswar, Land Council submits that he has instruction to appear for opposite party number 1 and 2.
1 and 2.
Who is this opposite party number 3? So loan has to that is notice has to be issued to them.
I'll take up notice.
Let a copy of the writ petition be served on Mr. Biswal. By tomorrow, you serve the copy and so by tomorrow. And so far as this opposite party number 3 is concerned, please by speed post with proof of delivery shall be filed within a week. This matter after 4 weeks. Counter affidavit, if any, be filed in the meantime. The appearance no by it of from frustrated like
Any more orders?
Passable item number 3.
May I please ask? My power is not that I filed the power yesterday only. And also an IA, my lord. Initially, IA has not been filed.
What do you want?
Well, I have filed my power yesterday only along with an IA in interim application for stay also.
So that has not come on record.
No, my lord.
All right, it stated that power has been filed yesterday along with interim application. That number has been
12229 of 12229
of
2024.
Yesterday. Put up this matter next week. These ones will be placed on record. The name of the engaged counsel be reflected in the call. You have obtained consent from the
yes, madam.
The name of Mr. Srikanth Panda and his associates shall not be reflected in the cause list henceforth. Yes.
He has some difficulty for that reason.
We are omitting the names. You
yes,
just include your name.
Yes, ma'am. Yes.
Item number 28.
And in this case, the petitioner, ମୁଁ ଏଟା ପାରିବିନି ଜମା ନାଇଁ ମତେ ଜମା କୁହନ୍ତୁନି ନାଇଁ ମୁଁ ଲାପଟପ୍ ଓପନ କରିପାରିନି ଜମା ନାଇଁ
ଆପଣ କ୍ଲାଏଣ୍ଟ ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ଦେଖୁଥିବେ
ନାଇଁ ପାରିବିନି ଯାହା ଦେଖିଲି ଯାହା କଲେ ଘରେ ଆଜ୍ଞା ସେ ଲାପଟପ୍ କୁ ଦେଖି ସାରି ତାପରେ ମୁଁ
ଦେଖନ୍ତୁ ଆପଣ ଜଣକୁ ରଖା ହେଇଛି ଆପଣଙ୍କୁ ହେଲ୍ପ କରିବା ପାଇଁ ପଢିବେ କଣ ଆପଣ ସେଇ ଫାଇଲ ଟା ସାଇଡ ରଖନ୍ତୁ ୟୁଜ କରନ୍ତୁ
ହବନି ମତେ ଗୋଟେ କହୁଛନ୍ତି ଆଉ ଏଇ ବୟସରେ ଆଉ
ପଢିପାରିବେ ତ ବୟସ ପଡିଯିବ ଦେଖନ୍ତୁ ସେଟା ଏଥିରୁ
ଘରେ ଲାପଟପ୍ ଅଛି ମୁଁ ଅନ୍ କରିପାରୁନି।
ଏଥିରୁ ପଢିବେ ସେଥିରୁ ପଢିବେ ଆଉ କଣ କରାଯିବ ସେତିକି ତ ଜିନିଷ ସେଇଟା ବ୍ୟବହାର ନ କଲେ କଣ ମାନେ ଆଉ କିଛି ଦିନ ପରେ ଆପଣ ମାନେ ତା ଉପରେ
ବହୁତ ସେମାନେ ସାନ ସେମାନେ କରନ୍ତୁ ମତେ ଆଉ କୁହନ୍ତୁନି।
ତାକୁ ସେଇଟା ଭାବିବେ ଏଟା ହଉଛି ଗୋଟେ ଥୁଆ ହେଇଛି ବୋଧେ ଚେୟାର
ମତେ କୁହନ୍ତୁନି।
କୁହନ୍ତୁ
ଆଜ୍ଞା, here in the case my lord, the petitioner is the auction purchaser and have deposited the money and sale certificate was issued in his favor. When physical possession was given to him, it was found that the land which was auctioned, that 40 piece mill, is not there physically. Along with the bank officials, he has gone there for delivery of possession, but it is shortage of total. Again, that it was found that बयालीस डिसिमिल जगह 25 डिसिमिल
So you are praying for the refund of that
again.
All right. Who is appearing for the bank?
I have instruction.
So you take instruction.
Yes, I am ready.
So this writ petition has been filed by petitioner Sibo Prashad Panda Freya for a direction to the opposite party to return the auction amount deposited by the petitioner along with the interest in favor of the petitioner. The government taken this one note for the annexures and council also submits that he has instruction to appear for the Punjab National Bank. Opposite party number 1 and 2. The dead end copy of the petition we served on the council for this one. You face of this matter. After 4 weeks, instruction be obtained in the meantime. Counter affidavit you can put up this like date. Yes.
Item 36. 36.
Pardon me, my lord. I am on behalf of Lalit Sahu. He is unable to attend, my lord. Kindly adjourn next weekend.
Mention is made on behalf of Mr. Lalit Sahu next week. Is this matter 17 September 2020. Next week as well.
Item 51.
Yes, my lord. I am for the opposite party bank. In this case, I had filed one caveat application, but my name has not been reflected there.
That caveat is also not on record. Can you tell us the number?
953. 9.
Please give it in a slip, and also your name so that it can be. Swans to submit that he has filed a caveat petition, but the copy of the writ petition has not been served on Swanson. Put up this matter next week. The caveat petition number Swanson, so the name of the land and council be reflected in the cause list. Which is she?